What you need to know about mediation and counselling in the family justice courts. To assist families undergoing legal proceedings at the family justice courts, mediation and counselling is used at the earliest opportunity for families to resolve disputes in divorce, separation, and children matters. Parents undergoing divorce proceedings in Singapore with at least one child aged 21 and below are required to attend mediation and counselling at the Family Dispute Resolution Division. What is mediation and counselling? Parties and their lawyers will meet with a court-appointed mediator for mediation and a court family specialist for counselling to resolve any disagreement over their divorce and related matters. Why use mediation and counselling at the FDR division? Mediation and counselling gives parties the opportunity to discuss their differences in a more amicable manner, so as to reduce tension and to focus on effective co-parenting for their child. Mediation and counselling sessions within FJC are non-chargeable. For cases where the dispute is only financial and substantial assets are involved, the court may refer the case for private mediation outside of FJC, for which market rates will apply. Benefits of mediation and counselling at FDR. Parties can learn to settle their disputes through discussion and negotiation as co-parents. Learn about the impact of divorce on children and focus on their needs when discussing parenting plans. Receive therapeutic support and referrals to community resources. There are 4 stages you need to know. Stage 1. The Family Dispute Resolution Conference. Parties with disagreements, together with any lawyers they have, will meet a judge and a CFS. The judge and the CFS will clarify the issues of disagreement and set the agenda for mediation and counselling. The judge will fix a mediation or co-mediation session. Stage 2. Counselling. At the end of the conference, the parties will attend their first session with the CFS, who will follow up with subsequent counselling sessions when necessary. Stage 3. Mediation or co-mediation. Parties and their respective lawyers will meet with the mediator to discuss about the disputed issues. Co-mediation is where the CFS steps in as an additional mediator. Stage 4. Conclusion of mediation. If there is an agreement, a consent order is drafted and will be recorded by a judge. If there is no agreement, parties will be referred to a judge for directions on preparations for a hearing. The counselling process. Court family specialists who are qualified and experienced mental health professionals will provide confidential counselling for parents and, where appropriate, their child. These sessions help parents resolve underlying conflicts and identify significant issues that are important to the family and child, develop skills to manage difficult and painful emotions, communicate effectively with the other parent on the needs of their child, and build a consensus on the care arrangements for their child. What to expect? Only parties involved in a divorce are required to attend. Parties and children may be seen individually or jointly, depending on the needs of the case. Lawyers are not required to attend. There are 3 steps in the counselling process you need to know. Step 1. The intake and assessment session. The first counselling session is known as the intake and assessment session. The CFS will assess what is important for each party, their plans for the future, their concerns and interests, and how their child may be affected by the divorce. During this session, the CFS may meet parties individually to find out more about their personal, family, and mental health history. Step 2. Further counselling sessions. The CFS may arrange for follow-up sessions to continue working on resolving the parties' differences and to reach an agreement on their child's living and care arrangements. Step 3. Drafting of agreement and updating the mediator. If parties reach an agreement on living arrangements and other issues during counselling, they can record a draft agreement that is witnessed by the CFS. The CFS will update the mediator on discussions held during counselling, and outstanding disagreements will be handled during mediation. Further support. To offer further support, the CFS will work with parties and their child to see if further support is necessary after counselling. Can refer them to appropriate community and social service agencies such as family service centres and divorce support specialist agencies with the parties' consent. May also contact and work with mental health professionals that parties and their child have been meeting with to better understand and provide more support for the family. Will alert the relevant agencies and persons, example, other family members, to keep the family safe if the parties and their child are assessed to be at imminent risk of harm. The mediation process. After counselling sessions with the CFS, parties will proceed with mediation to settle any unresolved divorce or ancillary matters. It is conducted with the help of a neutral third party called a mediator, who may be a specially appointed judge mediator, a staff of FJC, or a volunteer legal professional. When attending mediation, before you attend mediation, make sure you're ready to listen. Be open to the views of the other party without pushing your own too strongly. Put your child's interest first. When discussing issues with the other party, remember to come up with a solution that works best for your child. Consider getting legal advice. Divorce and separation procedures can be complex, and a lawyer can guide you through them. What to expect? The mediator will speak to parties and any lawyers they have to discuss the legal aspects of their case. The mediator will encourage the parties to understand each other's perspective and explore ways to resolve issues relating to their child and any other disputes. During the mediation session, the mediator could speak to the lawyers and parties in joint sessions or in private sessions separately. At the mediation session, if the mediator finds that there are complex legal and emotional issues to resolve in a case, they might call for co-mediation. It may take more than one mediation session for a settlement to be successfully reached. You may indicate to the mediator that you wish to reconcile with your spouse. If your spouse is willing to consider this possibility, the court may propose for both parties to attend counselling. What happens after mediation? If both parties can come to an agreement, they will reach a resolution where the terms parties agree on for the divorce can be recorded by a judge as an order of court. Once recorded, parties are required by law to abide by the agreed terms. If there is a major change in future circumstances for both parties, they may apply to vary the terms of the order if there is no agreement. If both parties cannot come to an agreement, they will have to go for a hearing where the court will give necessary directions for parties to prepare for the legal proceedings.